Welcome to this year's Columbia Arbitration Day under the title Rethinking International Arbitration Towards Transformation and Reform. On behalf of Columbia's International Arbitration Association and the organizing committee of this conference, we would like you to join us for a minute of solidarity with the people of Ukraine before we start with our program. It is with a heavy heart that we make this statement. Many of us dearly remember discussing and exchanging views with fellow Ukrainian practitioners on conferences just like this, or the Kiev Arbitration Days. And many of us have friends and family who found themselves in the middle of a war by surprise. As part of the international arbitration community, we do not want to remain silent to these atrocities, but condemn the invasion from the Russian government. We want to open our hearts to all the innocent victims of this unprovoked war. Also, we want to remember the victims of conflicts that left the spotlight of media, but are still raging. Today, our unwavering commitment to developing and promoting the rule of law, international law, and peaceful conflict resolution takes on even more significance. With this, I want to give the stage to Gabrielle Kaufmann-Kohler, who delivers the keynote on globalization and how to maintain international arbitration's legitimacy. As one of the top arbitration practitioners and Professor Emerita of the University of Geneva Law School, she needs no further introduction. Professor Kaufmann-Kohler, the floor is yours.
Thank you, Anya, and good morning to everyone. First of all, let me say that I wholeheartedly share in the message of solidarity and support for the Ukrainian people in this horrific tragedy. Then I would like to thank the student organizers for this invitation to Columbia Arbitration Day. I'm happy to be in New York today, even though it's only virtually. I do hope it will soon again be possible to be there in person, but right now we're certainly privileged to have this communication means. The organizers have asked me to speak about globalization and how to maintain the legitimacy of international arbitration. When I started to think about the topic, it looked like a huge subject was multiple facets. And so I looked for an angle of attack, something, one aspect of globalization that may improve the legitimacy of international arbitration. And it struck me that that facet could well be diversity. I would like to reflect on this topic with you this morning in 3 parts. First, I would like to explore whether and how diversity can improve legitimacy. Then I would like to review the current state of diversity, and then look at, in the third part, look at ways to enhance diversity. But before I go into this 3-part analysis, I must give some explanation about the relevant concept. And I would like to start with diversity. That term, of course, is familiar. It covers a broad range of ways in which people identify. It includes gender, age, nationality, origin, race, ethnicity, religion, culture, disabilities, sexual orientation, and socioeconomic status. Speaking of globalization, naturally, the focus will be on geographical or regional diversity, and that I use this term as a loose proxy for race, ethnicity, legal system, culture, tradition, and particularly relevant in investor-state dispute settlement, the level of development of a state. I will not speak today of gender diversity, which is the other most relevant diversity component in international dispute settlement. I will not speak about it, not because it is not important, but because it matters less in the context of globalization, and because also it is more advanced nowadays than regional diversity. The next concept that requires clarification is globalization. We all know what globalization is. International arbitration, as we know it today, is a product of globalization, of cross-border trade and investment, of development of transportation communication means, of increased mobility. As such, it is actually inherently diverse because of its international or transnational dimension, and because of the presence of actors from different jurisdictions. So the question is not really whether there is diversity, but rather whether there is sufficient diversity and whether there's a right mix of diversity for a given dispute and in the arbitration industry in general. If we watch the world today, we must admit that we are past the peak of globalization. With the financial crisis of 2008, nationalism, protectionism, sometimes populism have risen again, and the pandemic has further fragmented the planet, and the war in Ukraine brings us back to 19th century imperialism. At the same time, the almost global support for Ukraine these days, and in a completely different level, on a completely different level, but equally illustrative, the rapid global spread of the coronavirus have reminded us how interconnected the world is. And in such a world, at the same time interconnected, but in parts also torn apart, legitimate international dispute settlement is more needed than ever. The last concept that needs explanation is certainly international arbitration. Moving forward, I will put the emphasis on investor-state arbitration because this is where legitimacy is most heavily challenged. Not that commercial arbitration is entirely spared, but the level of criticism is not comparable. This is understandable. Investment arbitration has a strong component of public interest. Investment arbitrators rule on the international responsibility of states, and the result of investment arbitration can impact the fiscal resources of a state and thereby a state's population. Having now having set the scene by clarifying the concepts, we can now enter the three-step analysis. The first step being whether and how diversity can improve legitimacy. There are a number of reasons why diversity matters in international dispute settlement. One is that the need for diversity is recognized in most circles as a value, as a matter of justice towards underrepresented groups. I don't think that requires a long explanation, at least not in front of this audience. Another reason is that diversity is set to improve the quality of decisions. Now, so far, there's no clear scientific empirical evidence that diversity improves the quality of outcomes in international dispute settlement, which in any event is difficult to measure methodologically. But one would, at least as a matter of common sense, expect that a diverse body takes into account different viewpoints and thereby makes better informed decisions. More important for our purposes is that diversity increases the legitimacy of the dispute resolution methods. That rationale, of course, is important for any dispute resolution mechanism, but it is particularly relevant for investment arbitration, where the main criticism of the current system is that it lacks legitimacy. That criticism targets arbitrators, who they are, how they get appointed, and also their perceived lack of independence and impartiality. That criticism goes to legitimacy not as a legal notion. Legitimacy in international law arises from the consent of the state, and the states have given that consent to this system. But it arises more as a sociological notion. It designates the acceptance of the exercise of authority by those affected by it, who voluntarily comply with the decisions, irrespective of their content, and not because they are forced, but because they recognize the authority as justified, or if you prefer, as legitimate. And viewed from this angle, it seems obvious that an adjudicatory body that provides fair representation or a good reflection of those who may be affected by its decisions stands a better chance of being accepted as legitimate. Studies of perception of domestic courts, especially in the US, show that diversity can be a powerful tool to promote the public's confidence in the fairness of the judiciary. So now, having established that diversity can improve legitimacy, let's look into the current state of diversity in international dispute settlement. This is my second part, and as I circumscribed earlier, it will focus on regional diversity and investment arbitration. Now, what does the empirical data show? I didn't want to flood you and drown you in statistics, but I have selected just two slides with empirical data that hopefully will be enlightening. Can I ask Simon to show the first slide? Yes. Here you show, and you look at the bottom where it says all non-Western regions. You see that there are in total 26% of non-Western arbitrators appointed. The classification of the regions may be outdated, but the chart does capture the essence of geographical or regional diversity. And these figures include all investor-state arbitration from the start of this dispute resolution mechanism. And I've asked myself, because that will probably be more interesting, is to see whether there's an evolution over time. And so I asked my colleague Daniel Bain, who has a database on investment arbitration that is extremely detailed, to put together some figures that show on the second slide. Simon, can I ask you? No, the second one. Yes, good. The second one. And so the question is really, how has regional diversity fared in investment arbitration over the years? And the answer is unfortunately not well. As this compilation shows, strangely enough, the regional diversity was better in the early days of investment arbitration than it is today, 32%, and it has stagnated at 25-26% in the last 2 decades. I have no explanation for this. I can only guess that it may be linked to the professionalization of arbitrator activity, and that more professional arbitrators who are more often appointed are from the West. That percentage, Simon, you can stop screen sharing. Thank you. The percentage of 1/4 of non-Western arbitrators must be placed in context of the regional spread of the disputing parties in investor-state arbitration. The most frequent claimant nationalities are US, UK, the Netherlands, and Germany and Spain. So these are all Western region. All-time most frequent respondents are Argentina, Venezuela, Spain, and Egypt, all non-Western, but for Spain. A more granular analysis of the numbers in recent years would show some diversification of nationalities of claimants and respondents as businesses from emerging economies invest increasingly abroad, and developed countries are more and more targets of investor claims. But even taking these changes into account, the disconnect between those who make the decisions and those who are at the receiving end of the decisions it remains striking. What are the causes of the current state? Well, historic underrepresentation, of course, maybe also unconscious biases, insufficient opportunities for new entrants from underrepresented regions, and that is linked to the limited information that is available on less visible candidates. And also there must be, what must also play a role is risk aversion of those who make the appointments to first-time arbitrators, compared with an overvaluation of prior experience. And that leads me now to my third part. How can regional diversity be improved, and thereby how can legitimacy be improved? It is not my idea now to draw up a long inventory of measures. That would be tedious, and others have done this. Let me just make 3 comments. First, after this rather sobering data, the good news is that the awareness of the need for regional diversity and the existence of a deficit in this respect is growing. There's a gradual change in gradual shift in mentalities making its way. To what extent this awareness is accompanied by a consciousness of unconscious biases, that is open, but it seems clear that the awareness and some consciousness is growing in most societies, and of course also in the international dispute settlement community. The second comment is that as a consequence of this growing awareness of the need of regional diversity, we are witnessing a number of initiatives by states. States take initiatives in investment treaties, for instance, the EU or regional organizations of states, if you prefer. The EU treaties provide for court-like investor-state dispute settlement that builds in nationality requirements that are tied to the contracting states and yet ensures neutrality and impartiality. Other states' initiatives are discussed in the UNCITRAL Working Group 3 on the reform of ISDS, where the lack of diversity has been identified as a major concern that needs to be remedied. Now, how could the reforms increase diversity? One reason for the slow progress is the appointment of arbitrators by parties and counsel, which tends to perpetuate the pool of usual suspects chosen for their prior track records as arbitrators. So some states, probably not all, might well change this in favor of appointment by arbitral institutions of all arbitrators. The arbitral institutions' record outperforms that of counsel or parties, if you prefer. Another proposal is for parties to select arbitrators from a list or roster of arbitrators pre-screened for diversity. And still another proposal is the creation of a multilateral investment court or an appellate mechanism whose composition would need to meet certain diversity targets. Third, now leaving aside state initiatives, there are various actors in the field who have started taking action to promote regional diversity. First and foremost, the arbitral institutions in appointing arbitrators and staff also through staffing their internal bodies. Other organizations have launched various projects in furtherance of diversity. For instance, the Racial Equality for Arbitration Lawyers initiatives, or REAL. There are projects giving access to information to less visible arbitrators from arbitrators from underrepresented groups. For instance, the list of African arbitrators published by the African Arbitration Association. There are also large companies that start demanding diversity from their outside counsel, both in the composition of counsel teams and in the constitution of the lists of candidates for arbitrator appointment. Third-party funders can also play a diversity-enhancing role. Burford Capital, for instance, has set up a fund to finance litigation arbitration entrusted to racially or gender diverse lead counsel. And last but not least, law firms can be instrumental in promoting regional diversity, racial, race, in terms of race, region, origin. They can do so through hiring, through mentorships, through partner promotion, and obviously through arbitrator selection. It's hard to say, to predict which initiative will produce which result. They all somehow supplement each other, and they all deserve attention and support in the interest of a dispute settlement system that is legitimate and perceived as such by all stakeholders, a legitimate international dispute settlement that the world needs in troubled times more than ever. I thank you all for your attention.
Thank you very much, Professor Gabrielle. We'll wait now for the speakers of the first panel to join us in the meeting, and we will soon begin. We are just waiting a second for our last panelist to join us. So, good morning, everyone. On behalf of the Columbia International Arbitration Association, I would like to thank you all, panelists, and our amazing audience for joining us this morning. Before we start the first panel, we would like to make some quick announcements. For those interested in CLE credits, this panel is accredited for 1.5 credits for skills. You will need to submit the attendance form and the evaluation form, which are available to download at CAD's website to the email there indicated. Please record all attendance verification codes displayed during the program. You will need them to fill the attendance form. Review CAD's website to see the instructions regarding the CLE credits. We have also uploaded reading materials related to the topic of this panel. In addition, because of the COVID-19 pandemic, this year's CAD must be held online with the advantage, however, that we have been able to waive the registration fee and to make CAD 2022 free of charge. That said, in light of the current situation in Ukraine and of the many conflicts that are still raging worldwide, we would like to invite all participants to make a donation to a humanitarian organization of your choice. With that said, we would like to introduce our moderator for today, our dear Professor Robert Smit. Robert Smit is an independent international arbitrator and adjunct professor of law at Columbia Law School. He's also a former partner at Simpson Thacher, where he chaired the firm's international arbitration practice. Professor Smith received his Bachelor of Arts from Cornell University, JD from Columbia Law School, and Diplôme d'études approfondies from Sorbonne in Paris. So, Professor Smith, you have the floor.
Thank you, and good morning, everyone. The topic of our panel this morning is is international arbitration keeping up with new ways of doing business? And I must confess that your moderator is a bit nervous about this topic because I feel like an old dog being asked to teach new tricks. Back in the 1990s, way back then, one Friday night, I was at work and I posted on a listserv platform an article that I'd written about electronic discovery in international arbitration, which was a futuristic topic back then. And I sent it to the IBA Arbitration Committee and all IBA members to consider in connection with contemplated changes to the IBA rules. So I leave work Friday evening, and then I go home expecting a nice, relaxing weekend. I wake up Saturday morning, and I have received literally hundreds of emails from all over the world, angry emails from civil law and all kinds of lawyers saying, say no to electronic discovery in international arbitration. Say no to Smit. I thought my international arbitration career was over, and technology still makes me uncomfortable. But fortunately, I have wonderful panelists here today to help spare me from humiliating myself discussing new technology issues in our trade. Sophie Nappert is an international arbitrator extraordinaire based in London. She co-founded ArbTech, a global online community forum focused on technology and dispute resolution, created the Nappert Prize in International Arbitration, which is open to all you young scholars. I have Eduardo Silva Romero here, who's co-chair of Deckert's International Arbitration Practice, professor of investment arbitration at Sciences Po, and basically on everybody's short list for arbitrators in investment treaty and Latin America-related arbitrations. The short list is kind of Eduardo and everybody else. And then Judge Brower, who I could spend the rest of our session today describing his qualifications, currently at 20 Essex, partner at White & Case, acting legal advisor, State Department, judge of Iran U.S. Claims Tribunal. I could go on, but I won't. Let me turn to the format of our panel today. Amara's law, which was articulated by a Stanford scientist, Roy Amara, is that we tend to overestimate the impact of new technology in the short run and underestimate it in the long run. So we've organized our panel to address first today's short run technology issues in international arbitration, and second, tomorrow's longer run technology issues. The today issues are going to focus on remote hearings, and Eduardo and Charlie are going to share their experiences with remote hearings, which I think we're all doing today, and many overestimate will be the way of the future, even post-pandemic. And the tomorrow issues will focus on smart contracts and arbitration in the metaverse. And Sophie will explain what those things are and leave us to underestimate at our own risk their impact in the future. As we go forward, please feel free to chat any questions you have, and I'll try to put them to the panelists. We would like to keep this as interactive as possible. So with that, let's turn to today's issues, which are involve remote hearings. I would ask Eduardo first to share his thoughts on remote hearings from the counsel's perspective, and then we'll hear from Judge Brower on remote hearings from the arbitrator perspective. Eduardo?
Thank you, Rob, and let me thank the organizers for this very kind invitation to be in today's Columbia Arbitration Day. It has been 2 years during which we have been forced to participate in hearings remotely. And of course, we shouldn't complain about it. We should be grateful because we have been simply lucky to be able to continue our work in a different way. What I see today regarding these remote hearings is that we may identify two psychological moments in relation to this new way to conduct hearings. The first moment occurred, let's say, 18 months ago, in which we all, I submit to you, forced ourselves to like online hearings and remote hearings. And we forced ourselves to like these type of hearings because we didn't have any choice. And we better adopted some reasons to like them. But now, and this is the second psychological moment, now that we are hopeful that the sanitary situation is improving, we are seeing these remote hearings differently. And we are now finding some disadvantages in it. So these two moments really condition the few remarks that I'll share with you today about the advantages and disadvantages of remote hearings from the counsel perspective. If we come first of all to the advantages, to try to be positive to start with, I see four main advantages of remote hearings from a very down-to-earth logistical counsel perspective. The first advantage is that on my experience, remote hearings are great for lead counsel to be properly assisted without the arbitrators and opposing counsel noticing that you are being assisted. I explain myself. Given that the tribunal and opposing counsel only see the face of counsel either making oral submissions or examining a witness, you can receive a small papers or you can look at a Teams chat and get comments and help which go unnoticed thanks to these electronic means. I should say that this works either if the team is all together in a single place or in different places. But on experience again, I have found that remote hearings are much better when all the members of the council team are in the same place, which is a small paradox of the entire proposition, because if for remote hearings to be really effective, you need all the members of your team in a single place, that is not really the aim of having these remote hearings, especially because of the sanitary circumstances. The second advantage I see, again, very down to earth of these remote hearings, is how the documents are managed. I find very helpful that everyone is looking at the same document at the same time and at the same pace, which is the document being shown, of course, on the screen. That has made me discover excellent operators of an electronic core bundle, which is prepared for the hearing. Great platforms. We all know them by now, of these operators running remote hearings. And I have noticed that this way of showing documents really help gaining a lot of time during the proceedings. We can recall with some nostalgia, at least from my perspective, the time that the witness took to open tab 4 of the bundle and look for page 15 of the specific document, and how the witness didn't find the page, and some member of the counsel team helped that witness find that page. Now I think this time, even in future in-person hearings, that time is gone. I believe all the showing of documents in the future should probably be electronic. There is, however, one small problem, is that I have found some lawyers, especially from England, who find that it is against, they say, natural justice not to have a printed core bundle next to the witness or the expert during the examination of that witness or that expert. So that's something to overcome, I think, culturally, that eventually will happen. The third advantage that I see is one which is obvious, is the protection of the environment, essentially because we print less papers in remote hearings. And the last advantage is also obvious, which is that remote hearings are less expensive because counsel and everyone is not traveling, at least in theory. I should say, on my experience, that since we have found in the last 2 years that it's important for remote hearings to have the counsel team together in a single place, some traveling has happened. Some of the members of our team who are in the US or in London have traveled, for instance, to Paris to participate in these hearings from a single place. So there is still some traveling cost, perhaps because of our bias against the idea of having the members of the team in different places. But that's something, I guess, that someone could overcome. So given that I feel I am personally very much into the second psychological status or state towards remote hearings, I'll spend more time speaking of the disadvantages of this type of ventures, and I'll go through rapidly through six disadvantages of remote hearings. The first, which is one that many people refer to, is the difficulty that one has on the screen to perceive the reactions of other participants in the hearing, and essentially the members of the tribunal. It is true that in in-person hearings, because of the eye contact, you can feel whether an argument is being understood or bought by the tribunal. And during the examination of witnesses or experts, you can also notice more easily whether a line of questioning is over because the tribunal is not interested anymore in it. So there is a small issue of reading the tribunal, and in at least on my experience in these remote hearings, you don't see opposing counsel because of the protocol or the etiquette which is being adopted, which implies that only the person is speaking and the tribunal should have the camera on. So you don't know how your opponent is reacting to anything, something that happens in in-person hearings. The second disadvantage is also quite based on our experience, is what I would call lack of adrenaline. In in-person hearings, the fact that you are interacting in a single room creates a very special dynamic, I would say, which brings you from beginning to end of the hearing. I find that you don't have the same excitement in these remote hearings. Somehow counsel are more relaxed, and curiously, you are even more tired in this type of electronic hearings because of specifically the lack of adrenaline. And so I suspect counsel performance in remote hearings is not as efficient and good as it could be, and is in in-person hearings. Third disadvantage also from counsel perspective, is the difficulties that we find remotely to prepare the hearing. The practice used to be that 2 weeks, the 2 weeks just before the hearing, the team of lawyers, witnesses, experts, everyone got confined to get prepared. So now that doesn't happen anymore. We are all attending, I don't know how many video conferences per day. And so during preparation, you may have 1 hour here from the witness, 2 hours here from the expert. And the lack of concentration of preparation, I believe, is diminishing the quality of preparation. So there is something to rethink about whether some type of electronic confinement is possible. But so far, I have the impression it's not really in the customs of all of us. Fourth disadvantage, if the members of the team, if the client are in different locations, there are some difficult coordination issues for which I don't need to explain. I found it particularly difficult when the client couldn't come to be with the team of lawyers in a single place, because that creates some difficulties in receiving the instructions on time. There can be an issue of time zone, which obviously is the obvious inconvenience that we can find in these hearings. Fifth disadvantage, which is quite important from my perspective, is a time issue. As we know, the hearing day remotely is shorter than the hearing day in person. That has been decided, I think, rightly, because being at the screen 10 hours is really impossible. But the consequence of this is that since the parties have limited time to present their cases, my experience is that arbitrators now tend to put less questions to counsel and less questions to the witnesses. So I think counsel are not benefiting from more questions from the tribunal, which is always, I mean, from my perspective, a great guidance in for any lawyer to present a case. So I think overall this is bad for the process. But I understand the arbitrators who refrain from asking questions, especially if they feel that they are, so to speak, stealing time from the parties to put forward their cases. And last point, which to some extent is linked to what Professor Kaufmann-Kohler mentioned a moment ago, are what I would call technical issues related to some parties or some counsel located in some countries, specifically countries in which the internet connection is not good. So if the internet connection doesn't work, all the process doesn't work, or places where there is no equipment to properly participate in these hearings. I've seen solutions, people traveling to another country where there could be better connection, but that's not the idea behind these hearings. And I've seen some platforms providing kits to the different participants for them to have the equipment. I don't know to what extent these kits could be sent to all places, but especially of course now. So in conclusion, let me advance three ideas, especially in light of one legal question that comes up from time to time, is whether the tribunal can legally impose a remote hearing over parties who prefer to have an in-person hearing. We have read many papers on this issue recently. I believe that the issue, and perhaps I hope that the issue will be moot. Why? Because I think remote hearings over time will be limited to some very specific, not to say exceptional cases. I think remote hearings will be especially used for interim measures questions, which need to be organized urgently, as we know, simple jurisdictional pleas questions, some legal issues. I mean, I can imagine a phase of the proceedings on what is the applicable law to an issue that could be done or tried remotely. And another experience that I think is good remotely is ICSID annulment hearings that could happen also, since these are legal processes remotely. The second conclusion, second idea is that something that I have experienced and I find doesn't work is what is called the hybrid hearings, because the hybrid hearings create inequalities between the parties. Let's assume that the two witnesses from the claimant can make it and attend in person, but the two witnesses from respondent don't. Obviously, the examination of a witness in person is different from the examination of witnesses remotely, and that can create some inequality, at least from my perspective. So the hybrid nature of hearings really need to be rethought, and there has to be the same quantity of people on both sides attending of the same, let's say, caliber, and then the same number of people not attending from both parties, also from the same caliber, so that the hybrid hearings could work. And you already guessed it, that doesn't happen very often. The situations are always unequal in relation to who can attend this type of hearings. And lastly, something that my current state regarding these remote hearings has really confirmed is that at the end of the day, this arbitral justice that we have and we cherish is a mechanism of human justice for human beings. And so human contact, I find, is still of the essence. Thank you, Rob.
Thank you, Eduardo. Curiously, many of the disadvantages that Eduardo mentions from a counsel's perspective are advantages from the arbitrator's perspective. If Eduardo can't see me sometimes on the screen, that's good for an arbitrator. Sometimes we like to shut the counsel out. If there's a little lack of adrenaline in the room, that can be good. Let's focus on the merits. I know from my years as counsel that going to trial or hearing is a show, a performance. But from the arbitrator's perspective, we're just trying to get the case right. And sometimes a lack of energy and just a focus on the issues is exactly what we want. In terms of, Eduardo says, well, also the hearing days are constrained in terms of hours. For an arbitrator, that's a great thing. The fewer hours we have to, sit in a room listening to witnesses, potentially the better. And it does tend to focus counsel on the absolute essential in the case, which is what arbitrators want. They want counsel to focus on the key issues, and or not, hearings the tendency to focus counsel. I think from the arbitrator perspective, and I think Judge Brower is having some technical problems getting in, so I'm channeling Judge Brower a little now, as well as myself. But one of the challenges of remote hearings from the arbitrator's perspective is deliberations. You don't get the same, I mean, on the one hand, when you have Zoom hearings, it makes the kind of informal tribunal deliberations you'd have in the bathroom impossible. And that may be a good thing. But it also infects kind of the whole nature of the informal deliberation process. You tend to discuss the issues less and in less intensely when your time is on a screen with the arbitrators. I've now, my last 2 arbitrations as arbitrator, I have never met the arbitrators other than remotely. And that's a strange interpersonal dynamic to have with your arbitrators. In the last case I did, it was interesting. The arbitrators got together in one place in Paris, but all the counsel and the witnesses participated remotely. And that worked out well in several respects. I see that Charlie has been able to join us. Charlie, you want to unmute yourself and chime in here? We're just getting into remote hearings from the arbitrator's perspective.
I thought, oh, wait a minute. I think can you hear me?
Yes.
Okay. So I don't know where the show is because I've been on the line with the IT people, but
well, basically, Eduardo has told us about his experience from the counsel's perspective of remote hearings, and we're interested to hear what your experience has been from the arbitrator's seat.
No, right, I understand that. I don't want to interrupt another. You just tell me when to go ahead.
Go ahead. You're just interrupting me, and that's a good thing.
Okay, I wouldn't say so. Well, as you've seen from my late arrival, the problem for people like me is that I can remember having to learn how to use a television set because when I was in younger years, there was no television. We weren't brought up to be technically competent of necessity as younger generations are. And the difficulty, of course, is you have to learn this. And of course, I've been having to learn for at least 20 or 30 years since we first started having computers. When I was arrived in The Hague for the first time in 1983, there were no computers, but we didn't have desktops or laptops, and one's had to learn. Now I'm sitting at my what was supposed to be my dining room table, but it is covered with 2 separate computers, a monitor screen, an iPad, and sometimes we also have to be, as I just was, on the telephone. If you didn't start learning about these things until you were middle aged, it's quite a process. Have you seen? I followed all the directions, but I thought I followed all the directions, and I didn't get in so quickly. Now, actually, I remember being at the World's Fair in New York City of 1939 as a rather small child, but I remember it. And I'm the only one on this program who ever heard, I'm sure, of the main feature of that fair, which was called the Trilon and Perisphere. You can look them up in Wikipedia. So I've had an awful lot to learn. Some of this also is when you're in cases that have simultaneous interpretation. Well, that's why I have the iPad in particular, because there are different systems depending upon which medium is used for following the language or languages that you wish to. So this has been quite something. However, the biggest shock to me from remote hearings, frankly, is having to get up at 3 o'clock in the morning, my time, in Washington, because I'm usually on the western end of a geographically extended case with people in Europe, sometimes in South America as well, out in the Middle East, and even somewhat beyond. Now, that would be, I basically take 2 hours getting up at 3 o'clock to get on a 5 a.m. My time problem. And of course, one could jokingly say, well, you only get you only have to get half dressed because anybody can only see your upper body, and you could have tattered jeans or your pajama bottoms or whatever on. Well, that's kind of a funny thing, but frankly, I even have shoes on. I'm not barefoot. I've got everything that I should, because that's the way it's done. This has happened to me quite a lot. So you have to, you better be good and healthy and fit, because you got to adjust your system to getting very little sleep sometimes. And then the days are shorter because, say I'm getting up at 3 o'clock, getting on at 5 o'clock. The guys out in the Middle East are, it's coming up on dinner time, and you can only have 4 hours. I've had cases in which you only have 4 hours a day, so you have more days. The excuse me. Now the interesting part, apart from that, is all of the devices that are required in order to be sure that witnesses are not getting prompted from sort of off camera somewhere. I've had cases in which the tribunal insists that the room be swept with a hand camera to show all 4 walls what the setup is, and identify anyone else who is sitting in the room, and then everybody has to say that, we're the only ones here. Here's who I am. Here's who's this one. I don't find it difficult, as I think counsel have said in many cases, maybe some arbitrators, to follow the proceedings or the examination. To me, isn't any more difficult. And some of you might know that as an arbitrator, I ask a lot of questions of certain witnesses, particularly where credibility is an issue. Now, part of the disadvantage for the arbitrators is if a question comes up, you can't put your 3 heads together on the table, turn off, don't have a hot mic, and you decide right there some issue. But you have to go into a separate room to do that, hoping that the technology is working and nobody else is hearing what you're saying. That can be very disruptive. Now, I would say from the point of view of arbitrators, what is an advantage, in one sense, a financial advantage for the parties and counsel in a remote hearing of an arbitration is really a deprivation of the building of relationships among arbitrators. I've been doing this for so long. There are certain arbitrators I've sat with quite a number of times. It just happens to be that way. So if everybody's in the same city, the same hearing on the same time, the arbitrators are likely to have dinner together some of the evenings, if not all or most of the evenings. And that has 2 advantages. You get to know each other better if you don't already know each other. And if you already know each other, we get to know each other even better. I've often said our community is not a geographical community. It's not a family community. It's a bunch of people spread all around the continents of the world, except Antarctica. And we only get together when we're in arbitrations together or going to conferences. And getting to know people over a period of time develops your understanding of who you think is good, and in some cases who you might not be unhappy never to see again, which does happen from time to time. And it also offers an opportunity for, very informal, we're having a dinner and some wine and about what the day's events, what we thought of the witnesses, what we thought of arguments, what we think might be missing somewhere. It's not deliberations. You don't deliberate until the hearing is all over and the final submissions, if there are post-hearing submissions, are in. Now, I'm sure the clients are happy because that it's remote, a lot of airfare bills, and I'm sure we're thought to stay only in 5-star hotels and eat only 3-star Michelin meals. I have to tell you, that's not exactly accurate. Happens from time to time, but so savings of expenses is always welcome to the parties, but it is a disadvantage for the development of the core of arbitrators. Now, finally, I will say remote hearings, I don't think are going to go away completely. It's the less or the smaller the demand of the claimant, the more likely people are wanting to save money, not spend much money on the case. And I think remote will be reasonable. I mean, even within, let's say, the United States, if the claims are not too large. The problem, of course, is that the smaller the claims, the more likely people are to be able to get together geographically. And when you get to the multi-million, even billion-dollar claims, investor state claims, where certainly there are how should I say, political aspects to it when you're dealing with a state or a state-controlled entity. I think the bet the farm cases will more likely go into in-person hearings. So we're not completely away from it. And of course, COVID-19 and its variations are not entirely predictable. In any event, that's basically my 10 minutes of comments on how it looks from the point of view of, well, I won't describe myself other as seasoned, and others will make their whatever judgments they make. And sorry for the apparent lack of ability to get on the screen here at the appropriate time. Thank you for your patience, and it's a joy to be here. Thank you.
Thank you so much, Charlie. I think we're all grateful to know that you're wearing shoes. I cannot say the same for myself.
Oh, I see.
Let me ask you a question. I noticed in the ICC Commission's recent 2022 report on technology and international arbitration, the report talks about an arbitrator's duty of technological competence. That phrase sent shivers down my spine, and I'm interested to get both of your reactions. Judge Brower, your reaction in terms of having a duty of technological competence. And Eduardo, I guess the question from a counsel's perspective might be, do you consider arbitrator candidates' technological competence among the criteria you consider when you're choosing arbitrators?
So you'd like me to answer first?
Yes, let's get your view first.
I guess I've in this program getting on late graphically proven that I don't have the full degree. The problem was that you had to. My browser is Safari. I mean, I have all the browsers, but I usually use Safari. And as soon as I got on the one that they indicated, it just went anyway. Here I am. But absolutely, one needs to be technologically competent as an arbitrator. And you've got these systems like, I think of Opus, where if somebody hires Opus in the case, you've got, you got to be able to be sure you have documents that are shown on one screen, and you're looking at everybody in the room or whoever is talking at the time on another screen. And I have to tell you, and I'm, as some of you know, I'm sitting in, excuse me, 3 cases at the International Court of Justice as judge ad hoc. And I find that the system for dealing with translations, getting on usually English for me, and it's only English and French there, is very different from some other systems. You have to even master the particular, whether you're on Teams or Zoom or WebEx, it's all different. So you absolutely have to do it. Now, I haven't had problems in arbitrations with the technology, notwithstanding the graphic example of techno incompetence that I've given this morning. But I think it's absolutely necessary. And you remember the phrase, every day you must learn something new in this life. In this field for sure, and I think generally. So it's needed. And also security issue, not to protecting everything, is everybody's concern. So you've got to be as well equipped as possible to not have things hacked into your documents.
Thank you. Eduardo, any thoughts before we turn to tomorrow's issues?
Thank you, Rob. Well, I haven't really experienced or heard of any incompetent, technologically speaking, arbitrator. Well, we are all incompetent about these technological issues, but the truth is that in practice, before we attend these remote hearings, there are a couple of trial sessions which make sure that the incompetence is, to the extent possible, removed. So at the end of the day, I think these trials have become really customary. And because of that, the issue in practice, I suspect, doesn't arise very often. So I was a bit surprised when I read the document from the ICC, which seems to elevate this technological competence to the level of, let's say, availability of arbitrators, because in reality, I don't think there is much of a problem.
Thank you. I certainly agree. Let's move from today's issues with remote hearings to tomorrow's issues with smart contracts and blockchain arbitration. Some people predict that smart contracts and blockchain arbitration are going to replace contract law and dispute resolution by international arbitrators in national courts, essentially with code in the future. Sophie will explain for us what all this means and whether what role smart contracts and blockchain arbitration are likely to have going forward. Sophie?
Thank you very much. It's a great pleasure to be at the Columbia Arbitration Day once again. Thank you for having me. I will just preface this very briefly by saying, first of all, these are issues for the future. They're also present technologies that exist today, some of them in experimental form, but certainly they are things that are presently existing. They are not science fiction. The other thing that I will say is that in light of the current tragedy that's befell the Ukraine, is that it has, although I am going to talk about a future view of things, I do have my feet firmly anchored in the present reality. And when you have a conflict of that magnitude or any tragedy befalling an area, is that you lose the ability to access technology. You lose the ability to have a network. And so this is what, if only for that reason, I don't believe for 1 second that technology will override the possibility and opportunity to have in-person hearings in safe, neutral areas. Having said this, I'm going to ask, please, that my slides be put up. We said no slides, and I prepared a few slides because I thought a visual might help with some of the concepts that I'm going to talk about. And by all means, this is not meant to prevent or fetter any questions in the comments on the chat as we go along. Please put them in and we can address them. I want to start with smart contracts. Smart contracts, first of all, the first thing I will say is this field of legal tech is full of misnomers. It is a field that has appropriated itself some legal terms like contract, like arbitration, like fairness. That is not what a lawyer understands they are. It is something else. So you have to be a little bit, every time you read the techno jargon on blockchain or cryptocurrency or whatever, you have to be a little bit suspicious of the term does not mean its legal signification, and you'll see why in a minute. So the first thing I will say quite clearly is that smart contracts are not contracts. A contract is something that states the rights and obligations of both parties. It is not an instrument that does something. Smart contracts are a line of code that essentially automatizes the performance of certain obligations of the contract. So for example, transferring crypto tokens, unlocking an escrow account to deliver some money, or something as simple as unlocking an Amazon safe for you to get your purchase. That's what a smart contract is. It is not the substance of an agreement. So for example, when we discussed this presentation, my fellow panelists asked, how do you code fairness? How do you code reasonable endeavors? The answer to that question is we cannot at this stage, because codes are digital language is very binary, and it can translate things like pay the claimant when this happens, but it cannot translate, for example, I will have reasonable endeavors for this to happen. I will perform this obligation in good faith. This is not happening at the moment. A big endeavor of ArpTech at our very modest level is to have that conversation with the coders and the developers so that they understand how our minds work and how these concepts arise, and we can understand the limits of what code can do. Now, what smart contract can do is automate the performance of part of the contract that can be automized. So you can imagine, for example, in a construction site, in a construction contract or a long-term agreement, you can have milestones where certain things are performed and then automatically paid. This can be automized and is actually, as we speak, something that can be automized, and it is very efficient in terms of paper trail, in terms of transparency of verifying the history of obligations, because it's happening on the blockchain, which is an online, transparent record and ledger of these obligations. And the question has been posed by some scholars in this field, whether it might not herald a new era or a new way of drafting contracts, so that you could have a traditional contract with dispute resolution clause and all the information that we write in legalese. And then you have in some of those obligations that can be automatized so as to make the performance of the contract more efficient. It is a question mark, but it is something that can be considered. I have added a couple of slides just to show you what a smart contract looks like, and it's on Etherscan. So this is a smart contract, and as you can see, it is the author of the contract is anonymized. It is he or she is referred to by their wallet, by their code name, and they have put on a contract that does, I can't tell you what it does, but it is a contract that automatizes, I would suggest probably, if I'm guessing, the payment of money when certain things happen, which is the usual format that it's taking now. And the actual translation of the rights and obligations of the parties is this. Sorry, I passed on. There we go. So this is what legalese looks like in code. I am not obviously a coder. I cannot translate what that looks like, but it shows you immediately that you are talking about an area where you must be able to speak to the developers and the software engineers in order for them to understand how to translate these obligations as accurately as possible into code. The last thing I will say about smart contracts, unless there are any questions on this, is that in the past few days, the European Commission has issued the Data Act, which is a piece of European legislation that is meant to, in very broad terms, provide fairness and transparency in the treatment of data and how you can essentially control the data that you put out there. And one of the points that has captured the attention of the legal tech community is that there is a provision in the Data Act that says that smart contracts will be required to have embedded into their code an ability to interrupt or stop the automation process when certain pieces of data are being compromised in the way that the Act provides. It is very technical and not something that I want to dwell on, but it's very interesting because that would mean that a lot of the smart contracts that exist at the moment would be non-compliant with this law because they are made to essentially keep doing what they're asked to do when certain milestones happen. And this, what the Data Act is asking them to do is complicate a little bit and introduce a layer of nuance or complication to interrupt that automation when certain thresholds of data leaks are met. So this is going to be what I have to say on the smart contracts. Your takeaway message is they're not contracts. They are automation and they are a line of code. Right. My next slide is a little bit as a precursor to what I'm going to say about blockchain and blockchain arbitration. I'm not going to, by now, I think most of us have a very good sense what blockchain is. It is this record online of transactions that is open for everyone to see, that is between anonymized people who transact with each other. But the essence of it, and the reason why it is such a big disruptor to a field like arbitration, or the courts for that matter, is that it is decentralized. It is not an institution that has a central control of blockchain. It is several people behind a computer that all have an exact replica of what is on that blockchain and can all vouch for the fact that it remains immutable. And if a change is made to it, everyone knows that that change is made. It is not a decision that is taken centrally. Now, arbitration is not as centralized as the courts are, obviously, but we still have a degree of centralization in the sense that we have, arbitration institution, we have a community of arbitrators, we have a certain, we are a community. We are people who are do a certain type of decision making in a collegiate manner. We know who each other is. There is a complete and great reliance on who the individuals are. This is what it is at the moment. Now, there is a phenomenon called blockchain arbitration. Remember I said, beware the name calling. It is not arbitration. It is a way of deciding disputes on the blockchain. They call it arbitration very loosely because it, I don't know, sounded good. And also, I suspect, because there is a willingness to attract at one point down the line the application of the New York Convention. We are not far from it there yet, but that is another example of playing fast and loose with concepts. I want to talk about blockchain arbitration because at the moment it is limited to, I would say, disputes that arise in crypto transactions. So for example, if you want to list a certain crypto token, it has to meet certain criteria of eligibility or availability on a certain list. If it doesn't, then it is booted off. And who makes the decision? It is those panels of jurors who are other blockchain users in the crypto sphere and who essentially take a view as individually as a panel, and then the majority decision prevails. Is that token accepted? Is it not accepted? So one of these applications, I've talked about it actually 2 years ago. And last time I was at the Columbia Arbitration Day in person with Federico Ast, who is the CEO of this application called Kleros, who sits on top of the Ethereum blockchain. I will summarize a little bit what Kleros does. The reason why I chose to speak about them is I would say they are probably the most, first of all, it is humans making decisions. They are anonymized, but they are humans. This is not an automated artificial intelligence decision-making system. These humans who are blockchain users self-select to decide a certain type of dispute amongst Kleros's. They have maybe 6 or 7 courts, namely fora for dispute resolution of certain typical crypto disputes of different kinds, and they self-select by staking money in that court, and a little bit as if I were to say, well, I would like to be on this list of arbitrators, and I need to pay for that. That's the same idea. And they stake some money to be selected as arbitrators or as jurors. And where there is a dispute between, let's say, 2 users of the blockchain, one of whom had promised to transfer a good to the other, and that good is not compliant or the money doesn't arrive, the dispute is automatically sent to Kleros, and the panel is formed randomly amongst those who have selected. And those people don't know each other. And they come to a decision according to a system that is called the Schelling point, and that the Schelling point is a mathematical theory that says that someone must decide in a way that they think the majority will choose. And the way it works, it's called game theory, and the way it works is like this. So let's say we have a number of outcomes possible for a certain dispute, and then the jurors look at these outcomes and they say, okay, I want to decide with the majority on this. What would the majority decide? And the jury is likely to say the most likely outcome of this for a majority is going to be the number 1,000 because it's a nice round number. And then you have obviously all the anchoring processes going on in the brain. And then 1,000 is chosen, and 1,000 ends up being the majority decision. That's how game theory works. That is how Kleros has chosen to incentivize its jurors, because to incentivize them to come to a consensus decision is difficult when they don't know each other, unlike the community that we belong to, when their reputation is not at stake, where no one knows who they are. And the way that they have decided to incentivize them is by financially rewarding those who arrive at the consensus decision, at the majority decision, and by penalizing those who don't. Now, there is an appeal system that I'm not going to even get into, but this is, in very broad terms, how it works. There are other, Kleros is not alone in this space. There are other applications. One of them is called JUR, J-U-R, where you also have a smart contract system, but when a dispute arises, it is farmed out to a traditional low-cost expedited arbitration system. So there you have a bit of a hybrid system where the dispute arising on the blockchain is essentially sent to a traditional tribunal that comes to a decision in very, very quickly. Now, Kleros, obviously, we're talking about decisions in a matter of hours, at most a couple of days. Jur takes a little bit longer, but we're talking about maybe less than a week. This, you can see immediately the reason why this can be a disruption that can be very important for decision making in the online world, given that it matches the immediacy of online transaction and online transactions between people who essentially do not know each other. The reason why this is a development that matters and that we need to heed is the following. I have a few numbers just to give you an idea of the magnitude of the ecosystem that is cryptocurrency exchanges and transactions. The market capitalization of cryptocurrency is essentially the total value of all coins, just like Bitcoin, which is an example, or Ethereum, which is an example of a cryptocurrency. The total value of these coins is calculated by multiplying the number of coins in circulation by the current market price of a single coin. And just to give you an order of magnitude, Bitcoin as a currently has a market cap of $788 billion. Ethereum, second in line, has a market cap of $338 billion. So that money is not real money, but that money has a value. And I think what a lot of legacy lawyers find difficult to comprehend is, how do you ascribe value to something that does not exist? And that is, I think, once you get your head around that, you understand that even in that world that is online, even though these goods might be virtual, they still have value. And then where there is value in transactions, there will be disputes. And that is why the blockchain arbitration systems that are arising will definitely get into that space and will come to adjudicate on an increasingly valuable types of disputes. I have a couple of I have questions, criticisms, I would say, of the Kleros model alongside what arbitration is. And I would say one of my main criticism is the second one, where the Kleros system and blockchain arbitration in general is focused on maximizing the payoff to the jurors. It is not particularly focused on resolving the parties' dispute. The parties' dispute is being commoditized. It's being commoditized for the jurors to make money. It's being tokenized. And whilst this is completely acceptable to a community like the crypto community, because it's all about making money, in order to escalate or elevate a system like Kleros into the mainstream type of justice, I wonder whether that would not be a significant Achilles heel for more mainstream commercial disputes. At the moment, Kleros has received grants from the European Commission, as well as from the French state, in order to come up with a version of its system that would be more acceptable to mainstream commercial actors. They are working on this. They have established a fellowship of justice, as they call it, where scholars come on board to look at, what is the place of fairness, what is the place of due process in a system such as this. But I would urge all of us not to dismiss these developments, because as with Airbnb, this is a phenomenon that targets at first a very small segment, and then starts as it carries on and breeds familiarity and acceptance, it starts bleeding into more mainstream areas. I would also say that, to my mind, at the moment, I see a landscape of types of disputes. And you have on the left-hand side of my slide, the very sort of objective low-value binary disputes that can be solved even by artificial intelligence. And there are instances of that. That's not our topic today, but that works. Artificial intelligence overseen by humans. And then you have on the right-hand side what we do in traditional legacy international arbitration, the complex decision-making, the politically charged stakes, the very nuanced multi-party, multi-issue disputes that we deal with, where we are not seeing blockchain arbitration taking that on board soon. However, in the middle of that landscape, there is a whole phenomenon of e-commerce that is completely under the radar because what we do is too expensive. It's way too long. And decentralized justice, what Kleros calls what its service is, and jur, can do wonders at making e-commerce carry on its wheels, carry on turning, and its disputes resolved very quickly in a way that matches the values of the users of e-commerce. So immediacy, transparency, and speed and low cost. I will now say a word about the metaverse. What is the metaverse? It's a very trendy term right now, especially since Facebook, now Meta, has stepped into the fold. The metaverse is essentially, if you are a gamer, if you play games online, you will. That is pretty much what the metaverse is. It's a virtual world. You put a cap on, and you are immersed into this unreal environment where you can play games against others that are avatars, that are pictorial representations of others. The metaverse seeks, and here on my slide it is Web3, and I'm trying to this is actually not a slide made by me. It is a slide that has been published by others. But Web 2 is what we have right now, and this is what social media as we know it is: read and write, and it's interactive. There are platforms. It is centralized by Facebook, by others, and then Web 3 is meant to be about those avatars, those players transacting with each other. They are meant to be able to buy and sell from each other, all at the moment in cryptocurrency, all virtual pieces of land. You have real estate on the metaverse. You have Christie's and Sotheby's selling art on the metaverse. You have banks that have started building businesses on the metaverse. And again, I have numbers that defy comprehension. The sales of real estate on the 4 major metaverse platforms, such as Sandbox and Decentralized, topped $500 million last year, and I expected to double that in 2022. Someone recently paid upwards of $400,000 to have a plot of land next to a plot of land owned by a celebrity rapper. So again, the fact that the creation of this is completely artificial, unreal, not something that anyone can touch, does not mean that it doesn't have value, does not mean that as a matter of an economy, it does not exist. That economy exists. The metaverse to me, and here Arbitech hosted, I think, probably the first event on this topic back in December last year on dispute resolution in the metaverse. And we started from the premise that this was our chance, first of all, to get involved in this booming economy, and second of all, to devise a dispute resolution from scratch that would not have the same ills of time, cost, and hurdles that we keep complaining in conferences, but don't do very much to alleviate, and start from a blank slate, provide a degree of decision making that is fair, that is also mirrors the values of those users of the metaverse. And I have recently published in the the book in honor of Professor George Berman's career and life, a very short piece where I propose, I think a little bit provocatively, but I really do think that one of the answers should be there. And it is that a lot of the time and cost components of the legacy arbitration process have to do with the fact that procedural due process is something that takes time inherently. It is something that is time heavy, time reliant, and it just is not suited to this new environment of the online transactions. It isn't suited to it just because this is a world where we know when we go on Amazon and you don't wait ages, you pay, your transaction is done in minutes, and then you get your goods probably the next day. The dispute resolution system must match these areas, and frankly, for my money, the arbitration community, even though we practice a different type of dispute resolution, we do have know-how and experience that could be extremely valuable to devise that type of dispute resolution of the future. I hope this was helpful, at least to understand what smart contracts are not and what blockchain arbitration is not. And I would welcome your questions. Thank you very much.
Thank you, Sophie. We invite all the observers to send any questions you have by chat, but in the meantime, I'm still trying to get my mind around this, Sophie, and I guess two comments you made trigger big picture questions for me. One is you described the decision-making process as essentially kind of game theory. And you said that in the longer term, there may be a desire to get the benefits of New York Convention type protections to this form of arbitration. What's not clear to me is what actually is the role of law in dispute resolution in blockchain dispute resolution. It does not have, to me, an evident place. And what would be required to get blockchain dispute resolution to a place where it could actually be considered for New York Convention type protections?
So the first thing I will say is that Kleros uses game theory. It is very much their thing. Not all types of blockchain dispute resolution systems do. The Kleros's answer to your question is to say that at the moment, the disputes that they handle is very much based on the blockchain ecosystem and community and the crypto ecosystem and community, where essentially it's the equivalent of Lex Mercatoria that governs. What they call the Lex Cryptographica, for lack of a better term, which is essentially, if you cast your mind back to the very early beginnings of arbitration, is the law merchant, the way that things are done. The way that things are done in a trading community. That is the law that applies. I do not see why, or why not, there shouldn't be a proper system of law that applies. The difficulty, of course, is that those jurors are not lawyers. There is no barrier to entry to being a juror, just that you know the community, you know how things work, you know what to look for in the decision-making process. But in developing this system, there is at one point, no reason why there shouldn't be a requirement that it should be lawyers deciding, or that can be verified, that credentials can be verified, that we move towards something closer to what we know. As I said, this is a very experimental project, but it has the seeds of something that we should heed. New York Convention. Well, I mean, I have endless conversations on Telegram with Kleros about what is due process and whether the New York Convention will accept something like Kleros decisions. At the moment, it's quite clear that Kleros has a huge gap to fill in its decision making, just because it is unable to show any type of procedural fairness, and it is very difficult to see how to translate this procedural fairness in a game theory environment, where you essentially put your finger up in the air and say this is going to be the majority decision. To me, there's a disconnect. I will mention very quickly, though, that there has been a model law issued by on something called DAOs, DAO, decentralized autonomous organizations, which is a way, sort of an associate, the way that that the blockchain, like Kleros, for example, is a decentralized autonomous organization. The way that they organize themselves as enterprises on the blockchain, and that model law says very sweepingly that any decision taken in case of a dispute within the DAOs will have the status of an international arbitration award. And obviously, this is the sort of comment that gets me jumping up and down and feedbacking to them. It's not going to happen, and we need to find another way of making your decision enforceable elsewhere. But the New York Convention won't be it. But I would not discount these experiments. The intelligence of the people behind them, and the fact that they see there's definitely, as I said, a segment of dispute for which there is a need for that type of dispute resolution, tailored to make it more appropriate and more fairer procedurally for parties, and that is just a matter of time and trials, I think.
I did notice in preparing for this that some baby steps have been made in terms of even our traditional international arbitration world. You say smart contracts aren't contracts, but I notice that JAMS has now issued a set of smart contract arbitration rules. So there is movement, in our community to embrace this. I was struck when I went through the rules. They're really not that different than the ordinary international arbitration rules or domestic arbitration rules. So the question is there anything specific to smart contracts that would require specialized arbitral procedures?
I confess not having read the JAM rules, but if they are not very different from what we have in terms of time periods, for example, then I think they are missing the point, with all due respect. Because to me, the big difference between what we do and what we should be doing if we want to get into that space is the time that it takes. And the time that it takes, even expedited arbitration, even fast-track arbitration as we know it, will not take 2 days, right? And if you want to have a decision process that is fair, that gives a chance to everyone to be heard properly, and within that sort of space of time, then some heads need to come together. It can be done. It's just a matter of conceiving the process differently. And I am afraid that it's great that I think that institutions such as JAMS are making these initiatives, but unless they can compress the time and come with a new version of online dispute resolution fairness, then I think they're wasting their time.
Yeah, I can imagine a world where Eduardo and Charlie are putting in their coins to become arbitrators in this blockchain dispute resolution process, but I can't imagine them deciding a case based on game theory, what's the majority most likely to want to, where's the majority most likely to end up? It just seems like an unprincipled basis on which to resolve any serious conflicts.
You say that, but don't forget, we are talking about a decentralized system. We are talking about users of the blockchain who do not trust the musings of 3 people or 1 person chosen by word of mouth or otherwise, or imposed by an institution. They trust the judgment of their peers. That's the values that they champion. These are people for whom likes on Instagram or other social media are worth much more than what centralized institutions from the top down tell them to do. So when you look at it from that prism, then things start to, I wouldn't say that they make complete sense, but you can see where we need to adjust, is what I would say.
We have a question about whether it would be feasible to enforce an award that lacks territoriality because it's blockchain. I mean, in essence, what you're describing for us is like delocalization on steroids here. How
it is exactly
do we...
that. And that's a great question, because it brings to the fore, apart from the New York Convention application, it brings to the fore the other great challenge of these decisions is they are enforceable online with online assets. I described before that these assets are virtual and they're worth money. At the moment, these decisions are enforceable, self-enforceable on the blockchain, with assets on the blockchain. How you translate these decisions to enforcement outside, offline, is not something that has been done. And it's going to be a tremendous challenge and something that will need to be done at one point. But at the moment, there's enough money on the blockchain to not want to rush to enforcement off-chain and all the difficulties that this presents. And if you have, plots of land and so on that can be seized and enforced again on-chain, then maybe there won't be any need to go off-chain.
Well, for those of us legacy international arbitration thinkers who think that even in legacy international arbitration, a seat of arbitration is unnecessary, I think this would come as a welcome development. The only issue becomes the enforcement issue. And some of the enforcement would be automated through the blockchain process. And to the extent further enforcement is required, you go to traditional means of enforcement via national courts. But it is one further step towards the delocalization of dispute resolution. And it's food for thought. I think we have a time for one last question here. Do you think that a court may set aside a decentralized award, since there may be a party's right to know who their arbitrator is?
So to my knowledge, and I certainly under the New York Convention, that's not the standard. The standard is that a party has a right to know that an arbitral tribunal has been appointed, and in accordance with the arbitration clause. But parties that agree to systems like Kleros, for example, we're not talking about consumer arbitration here. We're talking about people who essentially are aware of how it works. That's going to be one challenge that they're going to face if they go mainstream. But at the moment, that's not what's going on. They know exactly how it works. They know that it's random peers on the blockchain who have no qualification other than their knowledge of the ecosystem and how it works. And so I don't think that this is the sort of query that is likely to arise, certainly as the system goes at the moment.
Thank you. I want to, our time is up here. I do want to thank so much our panelists for addressing these kind of current technological issues with respect to remote hearings and this eye-opening talk about smart contracts and blockchain dispute resolution. It will be very interesting to see you again, Sophie, next year at Columbia Arbitration Day and see where we are in this progression. But until then, I want to thank you all.
Thank you very much.